speculation is that you were suggesting that there should be a special tribunal for looking at banking-related disputes. Is that right?
Yeah, I said it should be something like
The reason
financial.
I say this is
Yeah.
that, and would you still say that, keeping in mind that the Supreme Court has even struck down or stopped the implementation of the NCLT itself, where it says that such matters should be, they should not be tribunalization, and therefore you are suggesting another tribunal.
I'm not saying a tribunal. What is the difference between a consumer court and a tribunal? Because consumer court is also one district judge or in a person who is qualified to be appointed as a district judge. Normally an advocate of 10 years practice. You all know, all of us sitting here know that they are appointed on a political basis. If one party comes, you are appointed. And then two members, of which one is to be a lady member. And, they are all, politically this thing. Only thing is, they may have a degree or, they may have a postgraduate degree. But that is not going to, you have to, I mean, I may take an MBBS degree, but I may have a driving license. If I have never in my life I have driven a car, I cannot comment on the driving of others. So likewise, so what I'm saying is, there is not much of a difference between the consumer courts which are functioning here. Not that they are not doing any good job, I'm not saying. But yeah, as far as complicated issues are concerned, that has to be dealt by experts. Experts.
Thank you. Shashank, so with that, I mean, your opening thoughts on the...
Yeah, I would like to cover 4 topics individually. First is delay in recovery, and the issue of whether there should be a separate forum for banking cases. Apart from that SARFACI Act, the most potent act which we have just now for recovery, and non-banking financial companies generally, as well as whether SARFACI should be applied to them or not. Lastly, I would also like to address the issue of tribunalization. In the sense, in fact, I would like to begin with, since you've raised it just now, when we use the word tribunalization, is basically whether the power to interpret law is given to a tribunal or not. In most cases, if an appeal directly lies to the Supreme Court, you are basically usurping the powers of the High Court. So if there's a tribunal underneath High Court, under the supervision of High Court, which would be the last forum where facts are thrashed out, and then they would refer the matters to the High Court solely on the questions of law, then that aspect is taken care of. I was, in fact, now coming to the first topic in my, the way I would like to go about it, the delay in recovery. In fact, I was going through a law commission report. It arose interestingly in a criminal matter where despite mandates of CRPC, where summons cases are to be finished in certain number of days, there were interventions by the High Court, and the matter traveled all the way to the Supreme Court. And it took numerous, years altogether, and Supreme Court has finally turned this case into a PIL, asking advice from all high courts, and also giving remit to the Law Commission to find out the delays. What are the causes, recurring delays? And there are huge, voluminous discussions about it. But interestingly, I find none about the financial sector. There's no discussion about the financial sector. Delay to great extent is because the volumes that we have to tackle with. To certain extent also, there's lack of proper training to deal with these matters. Here I would like to concur with Mr. Gopal Krishnan as to whether banking cases which per se deal with deficiency in services, with financial services, whether they should go to consumer forums or not. Presently, the way the consumer forums are, they are certainly not equipped to deal with such intricate matters which are like typical commercial transaction throws up. One example or one model which can be adopted would be like a railway claims tribunal. A railway claims tribunal could be a solution so far as banking cases are concerned, because so far as banks are concerned, there are 2 issues involved. First is recovery, as well as the consumer and the bank's relationship, which gives rise to so many cases for deficiency and claims, etc., etc. A railway claims tribunal presently, like this model we have in the country, deals with both issues. If your claim against railway as a contractual matter, you can claim, you can recover, ask for damages from the railway. Apart from that, it even compensates people, for example, if there is death while traveling, etc., etc. Also for negligence of service, negligence or deficiency of services, etc. So that's one model we can adopt. So far as SARFACI and DRT Acts are concerned, SARFACI uh, is a very potent legislation, piece of legislation, but it has not have had its full effect, unfortunately, because of the interventions from the courts in India. Although like our courts are like high courts and supreme courts are not only courts of law, they're also courts of equity. So somehow that equity principle comes into play, and under the writ jurisdictions, we are just now handling cases where almost 30, 40 cases where SARFACI actions were taken in Orissa. They all have been stayed, despite the fact there are repeated judgments of the Supreme Court where you can't possibly stay any SARFACI action till section 17, if you guys are aware of, section 17 provision is availed of. Then only courts can step into, and that too, you have an alternate remedy in form of DRT. Despite that, there are 26 cases, and and when I tell you what happened in the court, because of the amounts involved were small, these were actually small borrowers. Court's initial reaction was, okay, all right, let it go, you can settle with them. But that is not what impacts the system. The cumulative effect of all those small amounts, and long and short of it is that there's an act. There's an act. Equity can't apply if there's a direct provision of law. So far as non-banking financial companies are concerned, I was going through the Usha Throat report. Uh, I don't think at this point of time we have reached the stage where NBFCs can also avail the remedies which SARFACI Act applies. The reason being that banks with such huge volumes and greater control of RBI are far closely and keenly controlled by RBI. The stakes are higher. In fact, they accept deposits. Now, like since 1996, NBFCs can't take, no new NBFC has opened which takes deposits. Uh, NBFCs also range from those who have net worth of 50 crore rupees to one which run into thousands. So if you allow them also to avail SARFACI machinery provided by SARFACI, it would be more like list between two individuals or two parties, and that would further clog the system. You're already struggling with the trying to find measures to have expedited hearings, etc., etc. If we include NBFCs also, it's definitely going to clog the system further. These are my initial thoughts.
Just one, I mean, since I am from an NBFC, as I said, I cannot help, ask you one retort to that, is that how do you then, reconcile the fact HFCs, which are dealing uh, fundamentally with individual customers, have been given power or access to SARFACI, while systemically important NBFCs, where you're looking at 500 crores of capital or asset, where RBI has on-site inspections now, are being and are a very significant player when it comes to even things like project finance, and really are acting like banks, are not allowed. So I mean, how do I reconcile that?
Challenge them in court. Article 14, you have to challenge. That's a perfect case where equals are being treated unequally. And the remedy lies there. Or vice versa. At least the issue needs to be thrashed out. And people have certainty as to what forum they are eventually going to go.
No, I think Nilanjan has a case to say that when housing companies, housing finance companies are allowed to get their assets, say by through surfacing, certain NBFCs, should also be given the power, because, otherwise, challenging them in under Section 14 means, the rule making power, and, that rule making power of RBI is questioned and says that RBI has made the rule in such a manner that it is biased towards others, and, that's very difficult to prove, because, say then, that may be throwing up a Pandora's box on RBI, and others will also start saying that RBI has made some error. The thing is, see, when you are saying about recovery, SURFACI was enacted. The constitutional validity of that act was questioned. It was found that it is in order, except save and except one clause, and that was also amended. Subsequent to that, proceedings were going on. Then people started, the courts itself has made the entire thing in a mess by interpreting each of the section. Very recently, in order to stall the process, what happens is, suddenly a set of borrowers from Gujarat and, Delhi and Chennai went to the High Court and questioned that Section 2O of the Act, which, says that what is an NPA, the definition of NPA, and, that is cited with RBI saying that RBI's rule-making power is wrong, and therefore, so that matter is now being heard on a day-to-day basis in the Supreme Court today. So then I get stuck till the entire issue is resolved, because, so I cannot take any SURFACI action, because, the courts have a tendency to grant stay. And even if you file a criminal case against the bank authorized officer or an asset reconstruction company's authorized officer, and if I challenge it under 482, then the courts will say all proceedings stayed till the 482 petition is quashed. So I get stuck at every time. Very recently, the Supreme Court in Harsh Govardhan's case said under Section 14, where a magistrate has to be approached if I feel that, I need a police protection, or, I need some kind of a protection from the government to take over an asset and sell, because I feel that there will be a law and order situation, saying that they are empowered to look into the fact whether there is a tenancy or not. So these are all expanding the scope and, giving a lot of field for the borrowers to go and go and go. Look at the entire expense, very simple. DRT has to decide, a lender has given money, and it is proved by the fact that, he has received the money. The borrower has borrowed the money, executed certain documents. What more I needed? What is the more evidence I needed? Can't it decide and say that, you borrowed it and, you have lent it, and therefore you have failed in repayment? And it's a question, it's admitted by both parties, but then why drag it on for 2 years and 3 years by giving dates? This is all things, which has to be looked into it. That's what, to counter, today the governor has also said that, within 6 months DRT has to decide on it. But unless and otherwise, see, there is a mechanism, the judicial process. It is, it's a legal process which is dragging down the entire mechanism. Because I, being a lawyer, I'm a part of it, but still, when it suits me, I use it. And I'm not saying that when it suits, I won't use it. But because the system is like that, so it is that which drags the entire system down, and therefore recovery is something which is very, very, very difficult.
One thought to it, like if you're challenging any legislation, piece of any regulation for that matter, you're not imputing motives to the makers of it. You've maybe they drafted them with best intentions, but when it actually came to working, you found that they were not treating everybody equally. Lastly, about the principal cause, principal reason which appears to be the infrastructure is in shambles in most DRTs, and this is something which is a recurrent phenomena in most courts also, even in civil courts in rural, remote areas. Things are not even. In fact, we have had the occasion to deal with a few cases. In fact, Supreme Court is, by way of couple of matters which are still going on, looks into appointment and salaries of the various subordinate judicial officers all over the country. And you would be surprised to know that even, like for example, a progressive state like Gujarat, there is almost 30% vacancy in the subordinate judiciary.
So Shashank, that brings
that is something which percolates down the system, because eventually you are hiring people from the mainstream to man these tribunals also, like the subordinate tribunals. So this is like for example, the hospitals is one example. You can compare a district court or the lower courts with the kind of medical facilities we provide in some parts of the country, like this recurrent, like same problem, the problem of infrastructure is the basic fundamental reason why this delay.
So, you know, I'm sure you're aware that in January of 2013, so it's almost 2 years back, there was a Supreme Court judgment passed which said that high courts of each states should be, supervising the functioning of the DRTs. And so for all of these things which you said, which are administrative issues, they have infrastructural issues, because of which, so do you as a practitioner feel that, pursuant to that judgment, there has been any change in the functioning of the DRT?
No, not as of now. In fact, there's another thought on this account. For example, high courts, like the Chief Justice or the couple of few judges which form the committee who are basically, they have the mandate for all appointments, salaries, etc., etc. The fact that they have their own judicial functions, and apart from that, also these administrative jobs. For example, one judge takes care of one district, for that matter. They are already, there's huge pressure for appointments in the lower judiciary. And DRT, in terms of the courts, comes much later, because you have law and order situation, you have normal civil litigation between people. DRT in terms of importance actually comes much later than these first, like they need to fill these posts first. So I have not seen, I've seen cases where despite Supreme Court suggesting, for example, in Bihar, there were appointments were stalled because of dispute with the state government and the High Court regarding reservations in subordinate judiciary. The writ petition challenging the rules were pending in the High Court. And despite Supreme Court's slight suggestions, which we used to convey to the High Court, it took almost 2 years for them to finally decide the case. And not that they don't mean to decide the cases. The implications are large. That amounted that was in lower judiciary. The writ petition now being dismissed. Now again you have 230 vacancies. So you need to fill them first, because
230 vacancies in DRT?
Yeah, because no, in civil courts. In civil courts, because those.
But just coming back to